Docket, case number 111364 in the matter of Karen A. Eager, respondent.
May it please the court. Kate Baird appears on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, may I reserve 2 minutes for rebuttal, please?
2 minutes is granted.
Thank you. This original action is before the court after a hearing panel considered evidence of the respondent's misconduct back in January of 2014. On January 29th, 3 disciplinary matters were taken up by the hearing panel. In its February 18th, 2014 report, the hearing panel concluded that the respondent had engaged in multiple violations of the rules of professional conduct, and they recommended that her license be indefinitely suspended, although they did recommend that the court consider making that retroactive to the last day of her employment with the Disability Rights Center, which was at or near January 21st of 2013. No exceptions were taken to the hearing panel report. The matter then is before the court largely on the issue of sanction. The respondent in this case addressed, as I mentioned, 3 different disciplinary complaints. The first was referred to the attorney diversion program, and she entered into that diversion program in July of 2012. I point out to the court that was at or near the same time that issues were coming up with regard to her license to practice law. She was administratively suspended just 3 months after she entered into the diversion contract, and our office received a second complaint from another client. The diversion was revoked. That matter moved forward to the hearing panel, as did the second complaint filed by the second client. While the second matter was being investigated, her employers at the Disability Rights Center became aware that her license had been suspended. The respondent had been appearing, going into the office on a regular basis at the Disability Rights Center from September until January. They were not aware that her license had been suspended. She did not tell them that her license had been suspended. When they became aware of that, they immediately terminated her service, and the supervisor went through her files, and that resulted in the third and final complaint that came before our office, because the supervisor's assessment of the client files in her office led him to conclude that there were matters that were languishing in her, that were her responsibility and needed to be brought to our attention. At the hearing, the only matter to which, coming into the hearing, she had stipulated in terms of a rules violation was the first one. That is the one that had, where she had entered into the diversion, her obligation to her first client. The hearing panel report notes that during the course of the hearing, she begrudgingly, that's the word the hearing panel used, begrudgingly acknowledged other rules violations, and the panel concluded that the facts demonstrated that she had violated rules of professional conduct that included competence, diligence, communication, safekeeping of property, terminating representation, unauthorized practice of law, expediting litigation, and engaging in conduct prejudicial to the administration of justice and conduct that adversely reflected on her fitness to practice law. She did request at the hearing probation. The panel determined that probation was not an appropriate sanction in this case, and certainly we agreed with that. As I mentioned, no exceptions were taken. The panel concluded that the appropriate sanction was an indefinite suspension, and really I would suggest to the court that what the issue here is, how do you balance very serious misconduct with or how can that be mitigated, or how much should it be mitigated, the sanction by reason of mental health or physical issues. There was evidence presented that there were significant number of both physical and mental health issues that this respondent was dealing with at the time that this misconduct occurred. My recommendation at the time was a 1-year suspension followed by a period of supervision or probation. As a practical matter, if the court were to adopt the indefinite suspension as recommended by the panel, the respondent's license would be eligible for reinstatement, or at least she would be eligible to petition for reinstatement in January of 2016. If the court were to adopt the disciplinary administrator's recommendation of 1 year with a reinstatement hearing, she would be eligible to petition just a few short months before that. If this court were to enter its order and adopt a recommendation of suspension, an order of suspension, she would be eligible sometime in November or December of 2015. So there really isn't, as a practical matter, a significant difference in the effect on this respondent, but certainly there is as we assess what sanctions should be imposed for the serious misconduct, and when other lawyers look to see what sanction will be imposed. So I do see that that's a distinction.
What about reinstatement hearing and the CLE obligations that resulted in the administrative suspension? Do they have a role in the discipline you're recommending, or it didn't look like the panel mentioned?
Certainly, I would recommend that she be required to demonstrate when she seeks reinstatement that she has complied with all necessary continuing legal education hours.
It's your recommendation still today of a 1-year suspension?
My recommendation is a 1-year suspension with a reinstatement hearing. That reinstatement hearing, I would recommend that the court require that she undergo physical and mental health assessment and demonstrate prior to her reinstatement that she's fully participated in any recommendations made by the therapist, and demonstrate to the panel members that she has addressed the issues that contributed to this misconduct.
I note that she was admitted in 1997 to practice law in the state. Was there any evidence of a turning point, or have there been issues such as this arising as far as you're aware of since her admission, or was there kind of a point in time, maybe 10 years later, that problems started to occur?
This is from my recollection of the hearing. As I recall, the therapist testified that she began her treatment at or near 2005. I'm not aware of any other issues.
I'm talking in terms of the professional complaints or anything like that. Nothing occurred prior to these.
Not that I am aware of.
Okay, thanks.
Was there a diversion or vote simply because another complaint came in?
It was revoked because another complaint came in, and the failure to maintain her license. She allowed her license to be suspended and continued to practice. Our position was she continued to go into the office, hold herself out as a lawyer, and she continued to practice law. She entered the diversion in July of 2012. I can't recall exactly when the review committee directed, because we go back to the review committee and they will advise us whether or not the diversion should be revoked. But those were both contributing factors.
When we're talking about,
Go ahead.
when we're talking about physical and mental problems and vulnerability, I'm looking here, there's 1, 2, 3, 4 individuals that could be put into that category that lost their cause of action.
Yes.
And I mean, I started trying to tote up here how many hundreds of thousands of dollars that vulnerable people didn't get. Why isn't our duty here to protect the public from that kind of action and that kind of devastation? Why does 1 year solve the problem I see here of damage to the most vulnerable among us?
It may not. And certainly the court may conclude that a greater sanction is warranted, and the hearing panel did reach that conclusion. I had a conversation with the hearing panel during the hearing, suggesting that 1 year is a practical matter when you have a reinstatement hearing. Actually, is probably 18 months. It appeared to me, given the mental health issues and the treatment that she was seeking, it would take at least a year to actually address the issues that were contributing to this misconduct. Certainly, the court may conclude that it's going to take longer than that. It was very, very serious misconduct.
Any further presentation?
And not unless there are other questions of the court.
I see no more questions.
Just a couple more. She was suspended for not having her CLE on September 14th, 2012. When was her diversion revoked?
I don't know that I have that in the record. We would receive notice from the review committee that the diversion should be revoked, and then we move forward.
Okay. And she said there was some mix-up. I had my CLE, but it wasn't recorded right or
Right.
something like that. Regardless of the reason, was there any explanation why she just didn't go ahead and get it? Still to this date has not gotten it?
Certainly not at the time of the hearing. There was not. And other than, to paraphrase, she didn't give a darn. And that's basically, as I recall the testimony, she just, at that point, didn't care. And testified that she would fix it, she'd address it tomorrow. So there really wasn't an explanation offered, as a reasonable explanation offered as to why that wasn't taken care of at the time. I will also, I mentioned that she requested probation. I've not received anything to suggest that that request will be renewed today. There was nothing provided to our office by way of a representation that she continued to work towards a plan or implement a plan.
One of your initial objections to a proposal for a plan was that there was no supervising attorney who was nominated for that position.
Correct.
Any further questions? Thank you, counsel.
May it please the court, John Ambrosio on behalf of the respondent. This is the perfect storm case. My client has been fighting depression her whole life, from the time she was a child. And she's been in various therapies, and finally, in 2005, she addressed that depression. And if you look at 72, paragraph numbered 72 in the panel report, it indicates the respondent suffers from many health problems, including ovarian cysts, Hashimoto's thyroiditis, Lyme disease, Rocky Mountain spotted fever, restless leg syndrome, and depression. Additionally, the respondent had a breast cancer scare. It is clear that the respondent's health problems contributed to the misconduct. So what happened? We have somebody who's been fighting all her life against this awful, awful illness, and then everything else caved in on her. And it was the perfect storm when she was overburdened in a tough practice with about 80 or 90 clients, and she made some mistakes and didn't handle 4 or 5 cases the way she should have. And this is a bright, bright woman. And this is somebody who knows how to practice law, but everything just caved in on her right about the time that these complaints occurred. My client whispered to me, "I'm okay, John, with the recommendation of the disciplinary administrator's office." And she is, because she wants to continue with therapy. She wants to continue to deal with her health problems, and she wants to be reinstated to practice law. Now, I never denigrate cases that lawyers have in their office, but there are bad cases. And those of us who have been around the docks and the deck for 40 years know the cases that you take and the cases that you don't take. The cases that she was involved in, and again, these people have a right to be represented, and they have causes of actions like everybody else, but they were bad cases and probably would not have returned hundreds and hundreds of thousands of dollars. And
Well, let's look at that, Mr. Ambrosio. I'm seeing here that JS had lost his cause of action when liability was clearly established and when there was a $1 million policy limit.
That's correct.
Why is that a bad case?
That doesn't mean that the jury's going to give him $1 million. That doesn't mean
but
that the
they're going to give
damage is there.
something, aren't they?
Not necessarily.
Okay.
How many cases have you tried, Your Honor, where you thought there were great causes of action and you were going to get a lot of money and you received not one farthing? You know that as well as I do, Your Honor. And not to fight with you, but that's true. There are cases that can be a $10 million policy and they may look like they're damages and the jury gives nothing. And that's what the type of people she was representing, Your Honor.
And those people have an entitlement to have the jury make that decision.
Which I said at the beginning of my argument, which I agreed with you. And I disagree strenuous with you. She had some problems. And I said from the beginning, I'm not denigrating those claims. But what I am saying is, this is a woman who was in trouble. This was a woman who had the dirt being thrown over her from all of her illnesses. This is a bright woman. That's why my colleague in the disciplinary administrator's office suggested that she be given the chance to continue in therapy, to work on all her issues so that she can come back. And I think what they have suggested is exactly what is called for in this case. The panel indicated that she had some good in her. Her prior employer testified for her, the man who had to let her go. One of the lawyers who I respect in that office, Kip Elliott, who has tried cases all over the place and still works in there, testified for her. My law partner, who gave her some work, with the permission of the disciplinary administrator's office, testified that she was a good lawyer and her research was brilliant. She is flawed because of the illness and diseases that plague her. And to just throw on the dung heap is not what we should do. She should be given a chance after a hearing to work her program, to be supervised, and to be able to practice law. Without any further ado, my client would like to address
There
you.
is some further ado.
Certainly, Your Honor.
As I read the record, her supervisor, Lane Williams, was so concerned after reviewing her files that he self-reported his own possible ethical violations. Is that correct?
That is correct. That is absolutely correct. And then when he self-reported, then they realized it wasn't him. He was the supervisor, and they filed the case against my client. That is absolutely correct.
All right, thank you.
May it please the court. Thank you for hearing my case today, and I do apologize that you even have to be here today to address my actions, or more specifically, my inactions, as are present in this disciplinary complaint. It's very difficult when you're involved in a disciplinary complaint because, especially when you're someone like me, I'm zealous, I'm compassionate, and I'm caring about my clients. And I did fail these clients, Your Honor, there's no doubt about it. I did fail these clients, and I apologize. I take full responsibility for those actions. I apologize to the profession for any way that my actions or my inactions have had a negative impact, has a negative impact on the profession or on the integrity of the profession. I don't make any excuses. I don't. I hate excuses. I am solely responsible for these failures. I've been proud of the fact that as an attorney, I was working at DRC. It was my dream job. It was my dream job because I got to be a lawyer who got to go to court and practice, but really more importantly, I got to help clients learn to self-advocate. I got to help clients learn to resolve issues outside of the court. how to self-advocate, how to advocate for themselves, whether that's landlord-tenant or debtor-creditor or special education. All those things made me really enjoy and be able to use my law knowledge in a way that was outside of court, that helped people stay out of court. Because my clients couldn't afford attorneys and couldn't afford any kind of legal representation. And I've always been a really hard worker, and I put in long hours and I put in weekends, sometimes to my own detriment. And I took on a huge caseload, and I took on a lot of responsibility at the Disability Rights Center. It's a federally funded nonprofit, and I took on a lot of leadership responsibilities there. I took on supervision responsibilities. I was pretty much the sole litigator there. And so I took on a lot, and those taking on a lot is my responsibility, and I realized that. But I took on a lot because I was healthy, and I could put in the long hours, and I could put in the weekends, and I enjoyed that. I liked that. I embraced that. And then I started having a series of health problems, first with Lyme disease, which was late to be detected, and then later I've had 3 tick-borne illnesses. The last being that occurred right at the time of this was Rocky Mountain spotted fever. And at the same time, I was undergoing menopause and having issues with that made me really anemic. And then I also had the thyroid disease, which it's an autoimmune disease. It destroys your thyroid, which also causes anemia. That's the Rocky Mountain spotted fever causes anemia. It attacks the interior of your blood cells and your blood vessels, and all of that came together. It's well known. I've always had a depression, but I've always managed it. Depression's completely manageable, and I've always been managing it. However, I got so beat down physically, it wasn't about the depression anymore. It was just about physically being beat down, not sleeping, not feeling well. And yet I tried to plod away. I tried to keep my head above water. I asked for help at work. I don't think anyone took it very seriously, how sick I was, because guess what? I'm walking, I'm talking, I'm eating, I'm coming to work, I'm doing the best I can, I'm coming in late, I'm dragging, I have to shut my door, there's a lot of things going on. And so it was this one huge cluster of physical health issues that really got me down, that really just clobbered me. And I let my clients down. There's no doubt about it. I take full responsibility for that. Those clients are clients I had relationships with. Clients who I visited with frequently, who I met for coffee to keep them up on their cases. Those clients I was invested in. And there's no one more disappointed or sad about the ramifications of my behavior and my inactions than me for those clients. And so I stand here today before the court because I have a lot to offer the profession, and I have brought a lot to the profession. And I would like an opportunity to continue to practice law. I can guarantee you I never thought I would be here. I'm not that kind of lawyer. I'm not that kind of person. I don't generally get in trouble. I can guarantee you that if I have my law license back, I'll never be here again. You'll never see me here. It was a tough lesson. It's a tough lesson to learn how to take care of yourself when you are having a lot of different health issues, and none of them are fatal. None of them were cancer. None of them were life-threatening in that sense. You don't take it seriously yourself. I thought I could just plod along. I thought I would feel better tomorrow. And I said that so many days, so many mornings when I would get up, I would say, I'm going to feel better today. I know it. I'm going to get this done. I'm going to get that done. And you say that over and over and over again until, you're looking at these big failures staring you in the face. And if I'm allowed to practice law, again, you'll never see me here again. I promise you that. I will do something in the realm of what I was doing. I'm not a solo practitioner. You have no risk of me going out there and doing that. I've never liked being a solo practitioner. I'm a person who likes to help people who are in trouble in the law or who need help with the law. And that's why the job I was in was actually just a perfect fit. What I will do in the future, I don't know. Even today, even as I work as a non-lawyer, I can tell you that I still help people. I work for the federal contractor who does Medicare. I talk to Medicare recipients and advise them about their Medicare and their claims and their issues. And I also work with the health insurance marketplace, enrolling people into health insurance plans.
Counsel, before we get too far along, what is it you would like for us to do in terms of the level of discipline?
Ideally, I would like to publish an admonishment. I would like the court to see this in what an isolated instance this was. I have not practiced law. It'll be 2 years in January officially that I've been gone. I am healthy again physically. I am healthy mentally. I'm well. I would like a published admonishment. I understand, though, the court's concerns, and I understand the disciplinary office's concerns. These are very serious allegations. I let 4 clients down. I failed 4 clients because of my own actions and inactions. So I understand that. And if the court, believes that a tougher sanction than that is in line, then I would ask that you suspend me for a year and consider making it retroactive. And I will follow all conditions. I will do whatever kind of panel that I must pass or anything like that as needed by the court. I worked so hard to get through law school. I got through law school without a single student loan. I got through college without a single student loan. I work hard. I am a hard worker. I continue to work hard. I'm a hardworking lawyer, and I generally do not bring shame onto the profession, as I do feel like I did in this case. These are the very kinds of things that are cringeworthy when you're a lawyer, and I understand that.
Have you done anything to satisfy your CLE requirements?
I have not satisfied my CLE clients' credits for 2014 this year, but I did for 2013. I did not ask for reinstatement, even though I could have. I just felt it was okay to be away. I don't want to say it was a self-imposed suspension because I don't think that's fair. But I did meet all of my CLEs for 2013, and then given everything that was going on, I just felt it was appropriate not to ask for reinstatement, so I didn't. But I have not done anything for 2014 because, again, I'm suspended and I really didn't have the time or the money, given how much I have to work right now to do that.
Any further questions?
Do you believe that you caused any financial injury to any of these clients?
It's possible. The hardest thing with people with disabilities is the issue of damages, as the court's well aware. My clients were...
Well, for one thing, for NR, you withheld $5,500 in trust for 5 years.
I did not withhold that, sir. That was in the trust fund, and it was waiting for Medicare to give me a final resolution on what their share was. Now, I could have paid out the Medicaid, no doubt about it, but as Mr. Williams, my supervisor at DRC, testified, at the time of the hearing, my disciplinary, he couldn't even get Medicare to give him a results on that.
And where I'm leading to my question is, you indicated that you accepted full responsibility for what you had done to these clients. Has there been any attempt to take financial responsibility for any harm that you may have caused them?
No, sir, I have not taken any financial responsibility. I certainly don't have. While there is malpractice insurance, I'm unaware of anyone doing that. In terms of the financial responsibility, I don't know what that would be. The individual who was deaf I was represented, there was not a damage case. That was an advocacy case. The individual who was injured in the car accident, he subsequently died of a different result from different conditions. Most of that $1 million was going to go to Medicare and Medicaid because they had paid all of his bills. The hope would be to get him some money in that case, to help improve his life in terms of accessibility issues and things like that. But The biggest problem, that case was that he had become paralyzed as a result of the accident. At the time of the filing, there were more than $1 million in damages just through Medicare and Medicaid that we would have to first recoup. The individual who I was initially got the diversion on, which was a completely bad lawyering mistake on me and really is unrelated to what happened here. That was just a bad decision on my part. I had an individual who had a workers' comp injury, and during the course of the surgery of the workers' comp injury, he suffered some further injury, and he had gone to other lawyers, and it was about a pain pump, whether it was a defective pain pump, a case that I clearly had not the ability to do, and nor had any desire to. Came to me, he was close to the statute of limitations. I did some initial research. I found that there were pain pump cases out there, that there were class action suits being formed or multi-state jurisdiction litigation. And so the goal was to file the claim to preserve the statute of limitations for him and then get him to one of those other class action cases, because no attorney in this area was going to take that case because it was a work comp case. And his damages were limited. And again, he was on Medicare, Medicaid, and disability, which mitigates some of his economic damages. And so getting him into a class action was my goal. And unfortunately, once I dug further into the litigation and contacted some of those out-of-state firms, he didn't have the right etiology for their claim. He needed a specific diagnosis in order to fall into the class action pain pump case. And so it ended up, I paid for that out of my pocket. I had paid the initial filing fee. It was unrelated to Disability Rights Center. I was just trying to help him get to a class action suit or a multi-state litigation, in which none of them would take him. And so, no, sir, I haven't, done anything in terms of restitution.
Any further questions? Thank you, counsel. Thank you both. You reserve 2 minutes for rebuttal.
May it please the court, at paragraph 80 of the hearing panel report, the panel concluded that the respondent needed time to manage her physical issues further. The respondent needs sufficient time to reflect on the injury that she's caused to her client. I will suggest to the court that that there remains time. It's going to take more time. The comments made by the respondent with regard to her clients, I suggest don't demonstrate that she has an appreciation for the injury that she's caused. The individual, J.S., he was a disabled individual. There was a $1 million liability policy. Liability was not at issue. This was not a bad case taken at the Disability Rights Center. My recollection was that he did die, but the respondent had not taken steps to determine whether or not his death was in any way contributed to by the accident. And that was an issue that was not explored. So to say he died without heirs really makes it no harm, no foul. There hasn't been today demonstrated an appreciation for the real injury that was caused by her failure to prosecute that case.
Can the real injury for any of these people that were wronged be ascertained?
Financial, in terms of monetary damages?
Correct.
I don't know that it can be. It may be to some extent, but fully, I don't know that it can be. There were checks found in a file with regard to one of the clients. It was an agreement that she would send restitution checks to the court, and that had not been done. That's not a matter of having a bad case. That's just not getting something done. And clearly it was contributed to by mental health and physical issues. But I suggest to the court that what's been demonstrated today does not show that she fully appreciates the injury that was caused in spite of the reason, whatever reason it may be. These were very serious misconduct and serious injury.
Any more questions? Thank you, counsel. Thank you all for your comments this morning. Court will take this matter under advisement.